Obviously, open the meeting. I'll apologise for the delay. I'm sure most of you got caught in the roadworks, the same as we did at Thorpe Market, and landed up diverting all the way around the countryside. So apologies for that. A couple of quick housekeeping things. In the event you hear a fire alarm go off, please follow the members and we can go out. If you don't know where the toilets are, through the door there, left in the lobby, there's some toilets and everything there. I would ask that members of the public don't interject, etc., unless asked to, and that members and people that are a part of the hearing only respond to the matter subject and don't drift off. Okay, to receive apologies for absence, I believe we have one.
Yes, we have apologies from Councillor Harry Blathwaite.
Okay, thank you. Items of urgent business, I don't believe we've got any.
None received.
Okay, and schoolboy error, sorry, apologise. And of course, turn off your mobile phones if you wouldn't mind.
Just remind you to turn your microphone on, Chair.
Yeah, so declarations of interest, members at this stage, have anybody got any declarations of interest? Nigel?
Mr. Chairman, I should mention at this point the subject member is known to me, but it is a somewhat aged matter, and I don't see that as particularly relevant to our matter before us today. So, but I do need to make that very clear.
Okay, thank you very much there, Councillor Dixon. That's appreciated and noted. Thank you. Any other declarations of interest? Okay. As a code of conduct complaint is the reason we're here today. We're here to determine whether there's been a breach of the Catfield Code of Conduct, and if so, any sanctions that should be imposed. Take this point to introduce the members. I'll start at the far end if the members would like to introduce themselves.
Hi, good morning. I'm Roy McDonald, member for Loughton Ward.
Good morning. My name is Nigel Dixon. I'm the member for Houghton and Tunstead Ward.
Good morning, everybody. My name's Lucy Shiers. I'm the member for North Walsham West.
Good morning. I'm Pauline Porter, member for Bacton Ward.
Good morning, everybody. I'm the member for Poppyland Ward, Councillor Fitch-Tillett.
Thank you very much. The officers we have today, we have Cara.
Good morning. I'm Cara Jordan, the monitoring officer.
Morning, Matt Simmerich, and I'm the Democratic Services Officer.
Thank you very much. Also, we have the independent person with us, Charles Monteith, and the investigating officer, Joe Fenner. Would you like to introduce yourself, sir? So really isn't it? No others.
We have some persons sitting at the back of the hearing who are interested in this matter. With reference to this is a public meeting and being recorded, you have the option. Would you like to introduce yourselves?
Thank you very much. So I will now invite the monitoring officer to outline the procedure for the hearing. Cara?
Thank you. Parties to this hearing will have received a detailed procedure note, so I won't go through that step by step, but I will just outline the procedure for today. So the first matter is to consider any preliminary issues. The preliminary issue that we will look at is whether this matter can be heard in public or whether it needs to be in private session. Thereafter, once that decision is made, and members may retire to make that decision, or may ask members within this room to retire so that they can make the decision here. We will go through the usual procedure whereby the chairman will invite the investigating officer to present her report, and questions may be asked of her by members of the committee, the subject member and the independent person. At the chairman's discretion, he may invite a representation from the complainant on the investigating officer's report. And thereafter, the subject member is invited to address the committee and put their case and maybe ask questions. Thereafter, the independent person will provide their view as to whether the subject member has breached the code of conduct. The chairman will invite the parties, invite the investigating officer, the subject member, and the independent person to give any closing comments. And then they will retire or ask others to retire from the room so that they may make their decision. I will retire with them whenever they do so to make a decision. I am not involved in the decision making itself. I just assist them with the formulation of facts and reasons for their decision. Once that decision is made, they will return and possibly give a brief summary of their decision rather than the full written decision, which will be given thereafter. If it is found that there's a breach of the code, the members will consider what, if any, sanction is applicable, and will also announce their decision in that regard. Thank you.
Thank you very much for the overview there. To carry on from that, before we go to the next item, I should have mentioned when you first came in, it is a bit warm in here. If you wish to remove your jacket and go into shirt sleeve, feel free, because it does get very warm in here. Thank you. Right, just to move on to the next item then. As the whether or not this matter should receive in public or private session, I'm going to ask the investigating officer's view, subject members, and the independent person's view in turn. So, as the investigating officer, what is your view?
I have no objection to it proceeding in public. The only observations I make is the report does make reference to submissions of third parties. However, this can be adequately managed by not referring to them by name.
Subject member.
Somebody explain what the implications are of the difference between public and
I can assist with that somewhat, and I will be giving some fuller advice to the members a bit later on. But in public session, it means that everyone can stay in the meeting. It's also recorded, so is available thereafter on our eDemocracy YouTube channel. If it's in private session, then any persons not directly involved in the matter will need to leave, and it will not be available on our eDemocracy YouTube channel.
So your opinion would be public or private? What would be your preference? Okay, thank you very much. And the independent person?
Yeah.
Yeah. If you could give us any other relevant information you feel.
Thank you. I will give you some kind of structured information in regard to whether to help you assist in your decision as to whether this matter should be in public or private. You've heard from all the the parties here that they're content for the matter to be in public, but you will notice that in the papers, there is reference to individuals' names. And I have had some information from a person sitting at the back of this meeting that they do not have any objection that this matter is in public and that it proceeds and their names and the incidences as far as they're concerned may be in public. Could the three people at the back of the room confirm that they are content for the matter to be in public? So that's Mr. Reid, Mr. Snelling, and Mrs. Snelling. Thank you.
Okay, thank you very much.
Sorry, I do have
Go on then.
a. Thank you. The papers, even though those persons have said that they would be content for the matter to proceed in public and for their names and the incidents that they're involved in to be heard. There are other individuals who are named in the report, so I just draw your attention to that. In regards to what you need to look at as to whether the matter should be in public or private, the initial position should always be in favour of disclosure in favour of a matter being in public, so that persons can see the decisions that the council takes, and it's only in limited circumstances where information shouldn't be in public and where there is justification in law for doing so. So here the exemptions that were placed in the committee papers relate to Schedule 12A of the Local Government Act 1972 and relate to information that would identify or is likely to identify an individual. So information relating to an individual is exempt if and so long as in all the circumstances of the case, the public interest in maintaining that exemption outweighs the public interest in disclosing the information. And that's a similar test in regard to likely to identify a person. Then you go on to apply the public interest test. So it's clear that the information in the report and information that you're likely to hear is information that is likely to identify individuals. So you will consider the public interest test as to whether in all the circumstances of the matter, the public interest in maintaining the exemption outweighs the public interest in disclosing the information, and it's a balancing exercise. So matters in favour of the public interest test, and you're making a balanced judgment, is matters in favour of disclosure are such things as the general public interest in transparency. There may also be a legitimate public interest in the subject that the information relates to, such as elected member conduct, being able to understand the full picture, and matters that may go against the public interest is where it affects the right to a fair hearing or privacy rights and the specific circumstances of a specific case. So looking at the information that you've heard that the complainant is content for the matter to be in public, that two of the main witnesses during the investigation are happy for the matter to be in public. The investigator has indicated that is her position, as has the independent person and the subject member. As the subject member has indicated that he would be happy for the matter to be heard in public, it is generally the position that elected members in any event have less or should expect considerably more public scrutiny for their actions insofar as they're relevant to their public office than general members of the public. but he has indicated anyway that he would be content for that. However, members of the public have more of a right to privacy. So you will need to think about those other persons who are mentioned in that report and consider whether in all the circumstances, look at where the public interest falls and or consider whether you could hear the matter in public, but manage the matter so that those other persons, other than Mr. Reid, Mr. Snelling and Mr. Snelling, that their information is adequately protected. Thank you.
Okay, thank you very much for that, Officer Jordan. The committee members now will retire to the members' room and we'll have a discussion and we'll come back and give you our opinion. Thank you.
Chair, on a procedural point, could you just clarify, if we refer to any pages and all the documentation, do we use the large number at the bottom of the middle of the bottom of the page? Because very often there's more than one number on a page. Yeah.
Thank you very much. Yes, after discussion, the committee is happy to have this in public. It's in the best interest of openness and, you know, for what it's worth, people can see the clarity of what's going on. What I would ask, obviously, is, as we said before, please refrain from mentioning third-party names. I would ask members of the public at the back if you could also, I know it's an emotive subject, can be, refrain from any outbursts or interjection. It wouldn't go down well. Okay, thank you very much. So we will continue in public. At this point, I'd like to invite the investigating officer to outline the complaint and present their report.
Thank you, Chair. So you will have all received and digested my final report, and that was written following my investigation into the allegations that are before you today. I don't propose to go through that report verbatim, but for the purposes of the recording, I will take you through the salient points. Firstly, in relation to the legal position, I'll provide a summary of the evidence and then a summary of my findings and recommendations. You will note from the report that the investigation surrounds two allegations. The first in relation to a comment made by the subject member to a parishioner after the parish council meeting of the 7th of July 2021. And the second in relation to the subject member's conduct during the meeting generally. You will note from the report that following my investigation, I did not find sufficient evidence to support the second allegation. Accordingly, I only propose to focus on the allegation where I did find sufficient evidence to support a finding of breach of the Catfield Code of Conduct. Although at the appropriate juncture in my submissions, I will provide a brief summary of the information that led me to reach that conclusion. Are you content with that approach, Chair?
Yes, I'm more than content with that. And like I said, a brief overview of the other one would be much appreciated. Thank you.
Thank you. So I will give you a bit more detail about the complaint in due course. I'm just going to give you a brief overview of the legal backdrop in the first instance. So you'll have all no doubt be fully aware of the principle of the freedom of expression. This is a fundamental human right that everyone has a right to freedom of expression, which includes the freedom to uphold opinions and receive and impart information without interference by public authority and regardless of frontiers. And that's enshrined by Article 10 of the European Convention on Human Rights and in English law by the Human Rights Act. It is, however, a qualified right, so that freedom of expression can be restricted if that restriction is prescribed by law and it's necessary in a democratic society for the protection of the rights and interests of others. So how is this relevant to the standards regime? So the standards regime is underpinned by the Localism Act 2011, and that act is the legal mechanism what is prescribed by law that allows a councillor's freedom of expression to be restricted, and that is both by having in place the code of conduct and also by having in place this regime. Moving on, politicians are afforded an enhanced protection for their political expression. The nature of local politics and as an essential part of democracy, members will hold strong views. They may express them robustly during the course of debate. And it's a councillor's duty to challenge views, opinions and decisions of other councillors and officers. And indeed, case law has determined that in a political context, a degree of immoderate, provocative, emotive and non-rational speech is to be tolerated. And even aggressive, offensive and shocking speech may have its place in the cut and thrust of political life. However, purely personal abuse or deliberate false statements do not benefit from that enhanced protection given to political expression. So what does this mean for you? It means you need to give close and careful scrutiny to the allegations that a councillor has breached the code with regards to comments that have been made in his capacity as a councillor. If those comments are political expression, then it's very hard to justify restricting that speech through the standards regime. And even if you find a breach, any sanction imposed must be of a minimum that is necessary to uphold the public interest in local government being conducted to standards which maintain public confidence. Therefore, throughout this whole process, you need to be mindful as to whether it's appropriate to restrict a councillor's freedom of expression, both in your findings as to whether or not there's been a breach of the code and any sanctions you may impose latterly, should you find that there's been a breach. So moving on to a summary of the complaint, you will note from the report that there are 2 allegations of breach of the Catfield Code before you. The first is a comment made by the subject member. You ought to keep your mother under control, and that was made to a parishioner immediately after the Catfield Parish Council meeting on the 7th of July 2021. The second complaint is that the subject member was verbally abusive to some female parishioners during the course of the Catfield Council meeting of the 7th of July 2021, such that they left the meeting in tears, and that he is generally so, particularly towards women. The allegations, representations from third parties and submissions from the subject member are summarised in the report and are also included in the appendices in full. As I have said, because I've only recommended a finding on the first of these 2 complaints, owing to a lack of evidence on the second, I only propose to go through that complaint in detail. But I think this is an appropriate moment just to summarise why I reached the conclusion I did on the second one. I scrutinised, bear with me one moment. So having scrutinised the verbatim minutes and having listened to the recording, I could not pinpoint an occasion where the subject member was verbally abusive, and that included in the time leading up to the 4 women and complainant leaving the parish council meeting generally. There was no occasion where he used what might be considered offensive language or was insulting towards any person, including women. Furthermore, none of the representations by the women who did walk out of the meeting alleged that the subject member was verbally abusive or used any offensive language. And it's for that reason that I didn't find there was a breach of the code in that regard. So moving on to the first allegation. So the evidence is summarised it's covered in page 20 to 26 of the agenda. So the complainant says that the subject member made an offensive comment to a parishioner about the parishioner's mother immediately after the parish council meeting of the 7th of July. And that was in reference to the way she conducted herself during the course of that meeting. The subject member provided a response to that. He admits making the comment after the meeting. He explained that the parishioner approached him to speak about the North Norfolk District Council local plan. He says it was a private exchange between 2 adult men outside the business of the parish council. He says that the term and all its variants has become common parlance for the majority of people. He made reference to other political figures having used the term publicly. He says that the comments in question had nothing to do with the parishioner's mother being a female, and his response would have been same regardless as to who it had been about. So whether that had been a partner, a father, a brother, a partner, colleague, what have you. He says it was late, he was tired having chaired a meeting for 4 hours, and he did not wish to speak to the parishioner in question about parish council business, i.e. the North Norfolk local plan, any further. In order to make a finding against the subject member, you need to be satisfied of the following for this particular allegation. So firstly, at the time of the alleged conduct, the subject member acting as a councillor or a representative of the parish council. Secondly, that on the balance of probability that the alleged conduct occurred. And thirdly, the conduct complained of comprises a breach of the Catfield Code of Conduct. And I refer you here back to my submissions about the freedom of expression and enhanced protection afforded to political speech. I'll first deal with the issue of capacity and then whether the comment itself amounts to a breach. We don't need to worry about whether or not the alleged conduct occurred, as it has been admitted by the subject member. So in respect of the issue of capacity, I'll first off on page 5 of the agenda, you will see the reference to the relevant section of the Catfield Parish Council Code of Conduct. And this says, Catfield Parish Council has adopted this code of conduct to promote and maintain high standards of behaviour by its members and co-opted members whenever they conduct the business of the council, including the business of the office to which they were elected or appointed, or when they claim to act or give the impression of acting as a representative of the council. It's not on, I lie, it's not on page 5. I do apologise, it's page 5 of my report, which is, so it's on page 17, my apologies.
Thanks for correcting it. Do continue.
So the legal position is that when considering capacity, it should be determined as a matter of ordinary English using a fact-sensitive approach. So as a matter of ordinary English, was the subject member conducting the business of the Catfield Parish Council and or acting or giving the impression of acting as a representative of the Parish Council when he made the comment in question? The guide to the Model Code of Conduct provides further assistance in this matter. It states that the Code of Conduct applies where a councillor is acting in his capacity as a councillor, and this includes when carrying out official duties, for example, when considering or discussing local authority business, promoting and representing the local authority in the community, and acting as a bridge between the community and the local authority. It also specifies that it does not solely apply when in a local authority meeting or on local authority premises. On the basis of the following evidence, some of which has been presented by the subject member himself, it is my recommendation that the comment made was when the councillor was acting in capacity at the time that the comment was made. So the comment was made immediately after the parish council meeting. And it was just as the subject member was leaving the meeting, and it was immediately outside the meeting venue. So the parishioner had approached the subject member to talk about council business. As we've heard, he wanted to talk about the North Norfolk District local plan. And that's even if the subject member didn't want to discuss it. And finally, the comment in question is in reference to the actions of the parishioner's mother during the course of the parish council meeting that had just taken place, and relates to one of his functions as chair of the parish council meeting, and that is keeping the meeting in order. And it's for these reasons, it is my submission that the subject member was acting in his official capacity and seemingly still acting in that capacity when instructing the parishioner to control his mother during the parish council meetings. I am satisfied, therefore, that in accordance with the above, the councillor was conducting the business of the Catfield Parish Council and was or was acting or giving the impression of acting as a representative of the parish council when he advised the parishioner that he ought to keep his mother under control. So moving on to whether the conduct itself actually amounts to a breach of the code, providing, of course, you make the finding that the subject member was acting in his capacity. So this is set out on page 28 to 29 of the agenda. So whilst the law provides that some degree of aggressive, offensive, or even shocking speech may have its place in the cut and thrust of political life, purely personal abuse does not. I do accept to some degree that the variants thereof have become more common parlance. It's commonly used as an intensifier or to convey disdain. In this instance, it's used to convey disdain towards the parishioner's mother. It is my submission, therefore, that this falls into the definition of personal abuse rather than political expression. And on that basis, the comment is not afforded enhanced protection. I've also considered, as it was raised as part of the complaint, whether the comment could be interpreted as being misogynistic. Given the implication behind the comment was that it was the parishioner's responsibility to keep his mother under control, who was a person attending the parish council meeting, not as the parishioner's guest, but as a parishioner in her own right, I would suggest that it could be interpreted as such, and indeed has been, certainly by the complainant in this matter. I also, as part of my reasoning, wondered at the necessity of the comment, given that as an experienced chair, he should have been able to deal with such emotive speaking from parishioners with dissenting views in a compassionate manner, and certainly have a thick enough a skin not to be so affected by that it would result in him telling someone that they needed to keep somebody else under control. The issue is compounded further by the subject member's ongoing denials of any wrongdoing and insistence that his actions were entirely appropriate. This is despite a clear opportunity to make a candid apology for his actions throughout this process, and a further opportunity to reconsider this position when he was provided with the draft report and preliminary findings and recommendations. This, in my view, would have illustrated a greater degree of integrity. For all of these reasons, it is my recommendation that the comment was entirely inappropriate and disrespectful, both to the parishioner in question and the parishioner's mother, and amounts to a breach of the Catfield Code of Conduct, which requires that when a member acts, claims to act, or gives the impression of acting as a representative of the council, he shall do so in such a way that a reasonable person would regard as disrespectful. That's a summary of the report. Obviously, the report itself goes into a bit more detail, but I'm more than happy to take questions of clarification.
Okay, thank you very much for your overview and your report on that. I'll now go to members of the committee, starting with Roy at the end there, if you wish to have questions, and then I'll work my way this way.
No questions currently.
I have no questions, Mr. Chairman. Thank you.
No questions at the moment, Chairman.
No questions from me either.
Okay, thank you all members. Subject member, would you have any questions for the investigating officer?
Yes, thank you. The this whole business amounts really to two separate charges, one of which you decided I was not guilty of. In those submissions from several people, those several people all wrote to the council in January 2022. This is about an issue that happened in July 2021. Suddenly in January 2022, at least 4 submissions came in on the issue. I didn't know about those until August 2022, when I received the draft report. If you look at page 123, in the middle of page 123,
Could I just interject here? I mean, the investigation officer has already said this relates to the being verbally abusive during meetings, etc.
this
That's
is a
not,
question about the whole process.
well, that part that
And-
I feel has already been dealt with. Can I just refer back to the investigating officer and please?
It may be useful for the, just to identify the process in which when we receive a code of complaint, and it might just help to the subject member to understand the various points. So in the first instance, a complaint is received. The monitoring officer or deputy monitoring officer, on the request of the monitoring officer, will then undertake an initial assessment that's done in accordance with the criteria set out in the Constitution in relation to these matters. After that initial consideration of that first assessment, a decision is one of 3 decisions can be made. It may be there's no further action. It may be that there will be a consideration for alternative dispute resolution in lieu of an investigation, or it would be a decision then whether the matter goes to an investigation. In this particular instance, there was an opportunity to deal with the matter without the need to go to an investigation, whereby the subject member was given the opportunity to proffer an apology to the persons. And if that was done, then the matter would have been closed. In this particular instance, that didn't occur, and then therefore there was a decision made that the matter ought to go to an investigation. In those initial stages, the assessment is only made based on the complaint and the initial response from the subject member. No views or any additional information is sought at that stage. It's only once the matter goes to an investigation that the investigating officer will look to seek the views of other people. And that's why there's several months, you'll note, between that, because we've been through a process to get to that point. And at the point then those people were asked for representations, was the point where after it had been determined the matter would proceed to an investigation. So they formed part of the investigation. The investigation took place, and then a draft report was put together. The purpose of the draft report is to make sure that the parties involved have the opportunity to respond to the information that's been gathered as part of that investigation, to make any further representations they may wish, and to see whether that then impacts. And you can see I've been quite transparent. My draft report is included as part of these papers, and as are the representations made by the complainant and subject member following the draft report. And I've responded accordingly with some changes within the final report. But obviously it's a multi-staged process, and that is why the subject member those representations weren't sought until some months after the initial the incident occurred, and then he wasn't given the opportunity to respond because there was the investigation and further matters were investigated, and then obviously the draft report had to be put together.
Okay, thanks for the explanation. So
Well, my point is that those allegations about my conduct. Those allegations about my conduct of the meeting and other meetings in general, in effect, are a completely separate allegation. And I knew nothing of that allegation until the draft report came out in August 2022. Now, as I say on page 123, in the course of natural justice, I should have known that there are some allegations against me which are being investigated. Fortunately, the result of the investigation was I was found not guilty on those charges. Had I been found guilty of them, I wouldn't have known it until I got the result and told I've been guilty of an offence I didn't even know I was being charged with. And I think that's a very serious issue. And also regarding those allegations that were made in January 2022, all suddenly appearing at the same time and all stressing the issue of misogyny. It looks as if it's a concerted effort to provide those statements by somebody. What did the investigating officer?
can we just get back on track with the questions that you're actually asking the investigating officer as to her report and not things that you feel have been done out of turn, because they can be dealt with separately.
Question to her is, how did those people get contacted? Did she contact them or did they put themselves forward?
Chair, I wasn't actually involved in the investigation at that very stage, so I can't answer. I can't categorically give an answer to that. All I can tell you is those representations were sought as part of the investigation, and certainly received as part of the investigation by the officer who was dealing with it at that stage, and who latterly left the organisation. Hence, I filled the breach, as it were. But they were sought as part of the investigation. The complaint, the initial complaint, although it referred to the subject members being verbally abusive and during the meeting in question, it didn't at that stage. It was a very general complaint. So it wasn't until later during the course of the investigation that we then sought to get a bit more detail on that.
Yeah, okay, thank you for that. And with regards to that, there are methods and procedures in place. If you feel that this hasn't been carried out properly, you can follow, but you were given the opportunity in this draft report to respond to those. So it's not like you blindsided.
6 months later after the decision was made not guilty.
Well, that's, you know, by the by, really. If, as I said to you there, if you feel it's been carried out incorrectly, there are procedures and processes you can follow to challenge that. But that is not part of this. And at the end of the day, the bit that you're raising is not being discussed and considered here at the moment because you were found no case to answer on that. So it just sort of muddies the waters really to the real issue. So if you have any more questions for the investigating officer, please feel free.
To provide a balance, I suggested that the investigating officer should contact Councillor Pauline Grove Jones, our district councillor who attends our meetings, and Councillor John Toy, who attended some meetings, to get their opinion on my conduct of meetings. And I wondered if I got no reply. I wondered if that was done.
Chair, I didn't do that, but there was a good reason for doing that. My first port of call, obviously having had considered the representations by there's a number of those representations I had received, was to listen to the recording and to read the verbatim minutes. I was more than satisfied listening to those that the subject member hadn't been verbally abusive, nor did I have any cause to question his chairing skills. And for that basis, I didn't feel the need to contact any other persons who would support that view.
So as the chair asked the question, would it be fair to say in that case that the second allegation has got no real bearing on the first in the action?
No, they're entirely
fine.
separate
Thank you.
matters.
Thank you. Independent person, if you would, Charles, you have the opportunity to ask from the investigating officer any questions you wish. Thank you. I can, at my discretion, invite representation from complainant on the investigators officer report. Do you wish to say anything, Mr. Reid? Yeah. Can I just remind you that avoid names and emotional stuff, outbursts. I appreciate it's hard for people, but let's keep on track and on the item that we are actually on about, not the periphery that has been already decided. There was no case to answer.
Can I
Thank you.
just ask that Mr. Reid, sorry, come up to a microphone?
Yeah, just use any of those that's nearest to you. Thank you.
We're away. I'd like to start by thanking everybody for giving me the opportunity to make a short statement. I know it's now almost 2 years since the events which are discussed happened. And to me, for the problems that there are, it seems far too long to be going through this process. I have found the whole process very wearing, draining, and has without doubt contributed to my health issues, which has caused me to step down as the parish council chairman and also as a parish councillor. If Dr. Bacon had chosen to apologise to the Snellings for his foul language he admits that he used, I would have accepted that and the matter would have dropped. But he spoke at a parish council meeting saying that he had no intention of apologising, and everybody heard that. Now, for a parish council chairman and also a church warden, that's not the type of language you would expect. I'm no angel, I admit, I swear, but that's building site language, not for use in a public meeting of a parish council, and especially towards a lady through her son. Apologies to the builders. I don't mean them no disrespect, but that is the type of language you hear on a building site, and that's not to be expected. And I was asked by the Snellings, they spoke to one parish councillor who happened to be standing very close to them in the hall when this happened. He said to them, the best thing to do is go through your county councillor, which they spoke to. He then advised them, come and see me as deputy chairman to see if there was anything I could do to try and help. You know, as I say, an apology, I think, would have been accepted all round. But with Dr. Bacon refusing to apologise, this is why this has continued for the last 2 years. I don't think there's much else to add, because the other subject, as you say, has nothing to do with this one at the moment, so there's nothing else I can say on that one.
Okay, thank you very much for your input. I do apologise about time it's taken to do this, but obviously we've had a few things going on
Yes.
in the last couple of years.
Yeah,
So, yeah, I do appreciate your frustration and thank you very much for your
and I
input.
thank you all for your time.
Could you just turn your microphone off when you leave? Thank you. At this stage, I'd like to give the subject member an opportunity to address the committee on the report and to put forward any mitigation case they think or that information that the committee should hear. And so over to you if you wish to do so, sir.
Right, so if I could refer everybody to page 43. About me, there's some details there about me on that page. For over 40 years, I've been involved in all sorts of voluntary work committees, governor, church warden. It amounts to something like tens of thousands of hours of unpaid, no expenses work, except for the time when I was a North Norfolk District Councillor. I was born in Catfield and lived in a council house in Catfield till I was 22, which is relevant because the whole issue behind all this is about social housing. I'm a retired history teacher, 29 years at North Walsham High School. I also run the family holiday business on the Broads. Regarding swearing, it's very rare that I swear. I never swear in capacity in my role as a councillor or any other formal role where I'm chairing something. I think in the exceptional circumstances of having gone through chairing 4 hours of a particularly stressful meeting, an expletive came out in this occasion. I had several options open to me on this when I was reported. Firstly, I could have denied that I said it. It would have been my word against his. Or I could have said that he misheard what I said, and probably nothing else would have come of it. I could, as the officer suggested, have apologised, which would have been an easy way out, a simple apology, and it would all been finished with. But on a matter of principle, I don't believe I was acting in capacity in this, at this time, and I'm standing by my principles. I believe I'm in the right. I was a private individual in a private conversation, and I'll stick to that line regardless of the inconvenience or the outcome. The background to the events of the 7th of July 2021. I've been chairman of the parish council for 30 years. 28 of those years, it was a pleasure to be chairman of Catfield Parish Council. The last 2 years have been full of antagonism and stress, particularly because of 2 individuals. You prefer I didn't name them, presumably. Yeah, if I refer you to page 41, first paragraph, and 45, the last paragraph. In January 2021, I made a complaint about a councillor who was bullying the clerk. This is all recorded on Zoom and in verbatim minutes. North Norfolk District Council's officers refused to investigate because the man concerned told them and the then independent member that Catfield didn't have a code of conduct. They took his word for it. They didn't contact the clerk and ask her or anybody else. They took his word for it and said, because there's no code of conduct, we can't investigate. In fact, there'd been a code of conduct in place since June 2012, which I'd instigated having put in place after the 2011 Act. And because of the continual unnecessary ramblings about in the section of the parish council meeting where we accept the minutes, some of these bits of the meeting of accepting the minutes took 30 minutes. We went to a system of
can I
recording.
just get us back on track here? I appreciate your frustration and I appreciate the background you're trying to give us. And I don't dispute what you say. I've seen the minutes and as the rest of the members here have. But it's not, other than you're saying possibly it built up to crescendo of frustration that you snapped. It's not really relevant to what is being said. I mean, we've all read these and we don't need to go through them verbatim and look through in that respect. So if you have a point you wish to get to in order to either justify or mitigate or enlighten, stuff that's gone on years beforehand was undoubtedly frustrating to you and other people, is not really relevant to the matter in hand. So if you could tone it to
For the record,
relevance.
I feel that I'm being cut short unnecessarily, but and as you say, you've all got copies of the extremely long verbatim minutes, and particularly page 96 as where much of the key issues happened, where any other business ended in a retake of a vote and me giving a casting vote, which is perfectly correct. I wouldn't have liked I wanted to cut the meeting short at the point where any other business should have finished, but I felt that if I'd have done that, I'd have been accused of suppressing opinions and such like. Since then, of course, we've had the May elections. Councillor Reid, as he said, has stood down because of ill health. Scott Snelling has become elected to the council, and there were 12 candidates for 11 places. I got the largest number of votes in that election, as I have done at previous elections. Now, getting to the actual issues that we're faced with in this today, the key question is to do with capacity, and that all hinges around the word act. Now, in Catfield Code of Conduct, it says, as in many other codes of conduct, about act and acting, and the dictionary defines to act to include to put in motion, to activate, to animate, to carry out, to do, to perform. All of those definitions make it clear that to act involves purposeful action. It's not simply existing or a state of being. Now, while I was sitting in the chair behind the table in the meeting, I was acting as a representative or office holder of the parish council. When I was walking out of the village hall, I was Keith Bacon, a parishioner going home. At that time, I was not acting as a parish councillor, even if Scott Snelling would like to think that is what I was at that moment. As an analogy, in the theatre, if an actor is playing King Richard III, while he's on the stage, he's King Richard III. While he's leaving the back door of the theatre, he could be Laurence Olivier going home. Whilst I was leaving the village hall, I did not claim to act, which is one of the phrases used in the Code of Conduct. I did not claim to act as a representative of the council. No one says that I made such a claim. And there's no evidence that I was claiming to act as a councillor at that point. As I was leaving the village hall, I did not give the impression of acting as a representative of the council. The only impression I was giving was of someone leaving that building, the same as other councillors and parishioners. When I was approached, it was immediately clear from my response that I was not acting or claiming to act or giving the impression of acting as a representative of the council. I said, I don't want to talk to you. The fact that I made a comment about his mother's behaviour in the meeting could equally have been made by any other parishioner present at that meeting if they took exception to her interruptions and comments. The fact that Scott Snelling approached me on a matter relevant to the parish council does not mean I immediately have to start to act in the capacity of a representative of the council. If an off-duty doctor is in Tesco's and someone approaches him saying, "I've got a sore throat," that doesn't automatically put the doctor into doctor mode. He is off duty and can tell the man politely or rudely to go away. And likewise, if the doctor was leaving the surgery and was approached in such a way, he was leaving off work, he was out of the role of doctor. And if somebody approached him in the doorway of the surgery saying, "I've got a sore throat," likewise, he would have referred them to go and see the receptionist to make an appointment. A member of the public does not switch me on to act as a councillor. Surely I have some choice in the matter. To act is a conscious decision to fulfil a role, not an involuntary state of being switched on by other people. On page 26, the investigating officer recognises that the Localism Act of 2011 is vague on acting in official capacity. It says on the middle of page 26, I recognise that the Act is vague on the key point of what acting in official capacity involves, nor is there any case law arising from the Act to assist me on this. And in the Catfield Code of Conduct on page 26, the code says, the code then does not seek to regulate what members do in their private and personal lives. The code only applies to a member when conducting council business or when carrying out their constituency work. A distinction must be drawn between the individual as a councillor and the individual as an individual. A councillor is not a councillor 24 hours a day. And she goes on page 27, at the top of page 27, I think it is, to say, the principles for considering whether a councillor was acting in his official capacity were as follows. Was the councillor, as a matter of ordinary English, actually conducting the business of their authority, including the business of the office of councillor? Now, my contention there then is that I was not acting as a councillor at the time. I was not fulfilling that role as a councillor. After a long meeting, I was a private individual going home, and then was not the time to approach me to discuss council business. Now, if you decide that that's not, if you decide to disagree with me, then the alternative defence is on the human rights ground, the European Convention on Human Rights and the Human Rights Act 1998. On pages 17 to 19 in the report or in the bundle of papers, it says on page 18, the right to freedom of expression is crucially important right in a democratic society, and it is clearly may only be interfered with where there are convincing and compelling reasons within Article 10.2 justifying the interference, no matter how offensive and undeserving the protection the councillor's outburst may have appeared to some. The burden is on the investigating authority to justify interfering with freedom of speech. And in the case which is quoted there, Heason versus the Welsh Ombudsman, that it says that about the councillors, whilst freedom of expression is important to everyone, especially so for elected representatives of the people, the enhanced protection applies particularly at all political levels, including the local level, and that Article 10 protects not only the substance of what is said, but the form in which it is conveyed. and that can include a degree of immoderate, offensive or shocking language. And so on that line, there must be a convincing and compelling reason why Article 10.2, or within Article 10.2, to justify the Standards Committee to say that I breached the Code of Conduct by saying what they did to Scott. I said that in a one-to-one exchange of words while leaving the village hall. And this must be regardless of how offensive and undeserving of protection my comments might appear. So what was said was not said in a meeting. It was not said in front of other people. It was not said in front of his mother. It was a one-to-one brief exchange while leaving the building. So there is not a convincing or compelling reason under Article 10.2 to override my right to freedom of expression. Thank you.
Okay, thank you very much, you, Michael. I'll take this opportunity to invite questions to the subject member from the committee members. I'll start with you, Roy.
I have no questions. Thank you.
No questions, thank you.
You've articulated quite clearly through use of your own language that it was a stressful meeting, stating that it was very rare that you swear, and spoken about continual unnecessary ramblings of other people. So you've articulated your frustration, and you've also articulated that as a matter of principle, you won't change your stance on your conduct, which has been written in this document. And the point that you seem to be arguing is whether or not you were acting in capacity as an elected member, which poses the question, is it for members of the public to deem when and when we aren't acting in official capacity if we don't outline that clearly? As many members seated here will understand that we will quite often get approached by people who will ask us questions when we're in the supermarket or when we're out enjoying time with our family, and it's up to us to clearly articulate that we're not on duty and we would speak about this at a different time. However, when you interacted with the member of the public, you referred back to behaviour that took place during a meeting of which you were chair, and you were seated in a position to control the behaviour of that meeting, which intimates you were having a dialogue about your chairing of the meeting, which puts you in the position as chair when you're having that conversation and you were still on the premises of where you undertook your position of chair. How would the member of the public been able to differentiate between you acting as chair when you're talking about something of an action which you've just undertaken on the premises of where the action was taken? How were they to anticipate that you weren't acting in your public role?
Well, I think the circumstances after a 4-hour stressful meeting that was 10:30 at night or something, as I was leaving the building, I think most people would think this is not a time to engage me in conversation about North Norfolk's local plan. Obviously, I also get approached at all sorts of times and places to discuss public issues, and most of the time that isn't a problem. But I think this was not the right time, and I did make it clear when I said that I don't want to talk to you. Perhaps I could have been more polite about the way I spoke to him, but it was immediately after a long, stressful meeting. And I also made the point that it wasn't in my role as chairman or a councillor that I said about keeping her under control. It was any other person could have felt the same and could have said the same to him if they'd been in that hall and witnessed that meeting.
Yep, supplementary question.
So as chairman of the meeting, you engaged in conversation regarding behaviour during the meeting, and you didn't at any point say that you were off duty as a councillor. You engaged and spoke about behaviour which had just happened on the premises of where the behaviour had happened.
I didn't specifically say, perhaps as an opening line, I should have said, I'm off duty or something like that, but I didn't know.
No further questions.
No questions, Chair.
No questions, thank you.
I have one. I appreciate that what you're saying, you were acting in frustration, etc. Do you genuinely believe that as you were leaving the hall with a meeting you just chaired and you engaged a member of the public, that you behaved appropriately? And it would have been easier just to say that's an irrational outburst. It's not me, as you quite rightly said at the beginning. I believe you. I have no reason to disbelieve you about your language, etc. Totally out of character. And yeah, apologise. Do you not think that that would have been an easier way to acknowledge the fact that you had just been chair, you were commenting on that meeting, whether or not it was frustrating, annoying, a long meeting? I know I've been there. I've been a chair on a parish council for 4 years, and I appreciate that. I'm not sure I'd ever use that sort of language, but do you not think that this could have been handled a lot better by yourself and acknowledge the fact that it could have been interpreted that you were still acting in your capacity?
In hindsight, I could have handled it differently, certainly. And I regret making the comment. It is out of character. But my point is that it was out of character as a private individual. I am still adamant that I was not acting in capacity as I left that hall.
Okay, thank you for answering that. At this opportunity, does the investigating officer have any questions for the subject member?
I have no questions, thank you.
Independent person, do you have any questions?
You, and that is, you say it was a private conversation, so assuming that is right, do you not regard your words as being offensive, privately, person to person?
I wouldn't say I regard it as offensive.
Control your mother.
Yeah, yes, I think that's common parlance. I hear it all the time. I don't, extremely rare that I ever use such language, but I hear it all the time, and it's common parlance. It's on television after 9 o'clock every night.
You don't regard it as offensive?
I don't regard it as offensive.
Or abusive?
No.
Any further questions? No, thank you. Okay, at this point, I'd like to invite the independent person to provide their view as to whether the subject member has breached the code of conduct.
Thank you. Dr. Bacon has already outlined the code of conduct when it's applicable, when someone is acting or claiming to act or gives the impression of acting as a representative of the council. Well, the bottom line is he was acting as a representative of the council outside the meeting because, for two reasons. One, he was approached directly by Mr. Snelling on council business that had been under discussion in the course of the meeting. Mr. Snelling said it was about the planning that had been discussed at the meeting, albeit Dr. Bacon said, I'm not discussing it now, but he then added another comment about what had happened in the course of that meeting. And his other comment concerned the abusive comment about Mrs. Snelling, control your mother. That was about her behaviour and her behaviour only in the course of official council meeting. He was also holding out as if he was correcting someone's behaviour in the meeting, acting as a chair, criticising. So even if he wasn't deemed to be officially acting, he was giving the impression that he was acting to Mr. Snelling. So I don't think that you can argue successfully he wasn't acting in his capacity as a councillor for the reasons I've given. The second issue is whether it was offensive or not. He mentioned Article 10, freedom of expression. As we all know, it's not an absolute right, it's a qualified right. Doesn't give you willy-nilly the freedom to abuse people and be offensive to people at all. It's qualified. You have to show respect. As he himself quoted, respect is when a member acts or claims to give the impression as acting, as I said, as a representative of the council. He shall behave in a way that a reasonable person would regard as respectful. A reasonable person would regard what he said as being disrespectful, is what I'm saying. Doesn't matter too much of what Dr. Bacon thinks. It's what a reasonable person would take that expression, control your mother, as showing a lack of respect. And more than that, respect, the code goes on to say, means politeness and courtesy of behavior, speech. Debate and having different views are all part of a healthy democracy, as indeed Dr. Bacon has said. As a councillor, you can challenge, criticise, disagree in a robust but civil manner. This was not done in a civil manner, is criticism. You should not subject individuals to personal attack. This was a clear personal attack. The words he used, mother, was abusive and a personal attack. You should treat, in your contact with members of the public, you should treat them politely and courteously. Rude and offensive behaviour lowers the public's expectations and confidence in councillors. Just to remind you, we're dealing here with a member of the public, not a fellow elected councillor, not a politician, as Dr. Bacon has mentioned. He's not dealing with a fellow elected person. And even if he was, there's grounds perhaps to say that it would be offensive anyway. But putting that aside, he's actually dealing with a member of the public, precisely as the code has said. He was not treating her politely and courteously in his dealing with them. There's no dispute over the words used. He himself agrees that. I should say there's some mitigation, though, not just because it was a long, tense meeting that went over 4 hours that he had to control, and largely he did. The minutes I've read, and I can't see regarding second allegation, anything offensive, abusive or disrespectful at all in his conduct of that meeting. I would have to say there was some severe provocation he suffered in that meeting. And it's a two-way street with members of the public. Members of the public are also expected to show respect to their elected councillors. And when Mrs. Sterling called him a fibber, that clearly showed a lack of respect. At that point, he would have been, as chair, within his rights to give her a warning and ask her to leave the meeting. He didn't. She then comes forward and calls him a fibber again for a second time. He did not ask her to leave at that point, but allowed the meeting to go on. So there is some strong mitigation, but it doesn't excuse the offensive language and terminology used. And that is why I think he should have apologised there and then.
Thank you very much. At this point, any members of the committee got any questions for the independent person?
No question.
Councillor Shires?
You mentioned the word fibber. And the provocative nature of the phrase used. I think we're looking at potentially different phrases to have fibber and the reaction to be control your mother. I don't believe that that's balanced or warranted in terms of provocative nature, unless I've misunderstood the context of the word fibber.
Well, it was said twice. That's why I say it was. I think it did show a lack of respect. Maybe one, yes, I agree, but get away with in the heat and tussle of being an elected person, you have to put up with a certain amount. But being called it twice, and he did challenge her on the first time, and she said, "I called you a fibber," as the second time. So I think that was a lack of respect he showed, and I think he handled that well, actually.
Any other question, Councillor Shires? Any other questions from the committee? Okay. I was going to have a short break there, but we seem to have moved on a little bit from where we were. So I'm going to continue for the meantime. At this point, final closing statements from the investigation officer first, then the independent person, then the subject member, and then we'll move on from there, see what timescale we've got. Thank you. So the investigating officer, please.
Chair, I'm going to keep this fairly brief. You've heard from me in some detail and you have the report before you. Just going back, so if you're satisfied that the councillor was acting in capacity, if you're satisfied that the subject member made the comment, and if you're satisfied that that comment amounted to behaviour that breached the Catfield Code of Conduct, then you're entitled to find that there's been a breach of that code of conduct. It is my submission that all three of those parts are satisfied. I do hear and take on board the subject member's comments that a councillor's status is not necessarily switched on by a parishioner's approach, and note his comments. But for me, the key point was that the comment that is the subject of today's hearing was in reference to the meeting that had just taken place. It was in reference to the conduct of a parishioner during that very meeting, and in direct reference to his chairing role in terms of actually moderating conduct within a meeting. And therefore, I would ask that you find that or recommend that you find that the subject member was indeed acting in capacity, and simply, as I say, there's no issue in terms of whether the conduct did indeed occur. The subject member has admitted he made the comment. He stands by his view that he doesn't consider it to be insulting. I would submit otherwise, as I have done in my representations and my support, that the use of reference to the word was disrespectful towards the parishioner's mother, and caused not only disrespect to the mother, but also the parishioner in question, and therefore the subject member is in breach of the parish council code of conduct.
Thank you very much for your summary there. Independent person, if you had anything to add? No. Okay, and subject member, have you anything you wish to add to what has been said? It's your closing statement. No?
Agree with the comment about what was said. My argument is that I was not in capacity enough then.
Sorry, can I remind you to turn your microphone on?
Right, yes, that I agree with the words that I said. I feel that I was acting incapacity. I was not acting in capacity at the time of this, and the mitigating circumstances are that it was a very limited brief exchange between two adult males with no other people in hearing, and that's it. Yeah.
Okay, thank you. If you'd like to turn your mic, thank you. Okay, any advice from the monitoring officer?
There are two matters in the investigation report. One of those matters relates to conduct at the meeting itself. No breach was found by the investigating officer, who you have heard has looked at the verbatim minutes and also listened to the recording of it, and finds there to be no breach. And you've also heard from the independent person and the subject member in regard to that. Your focus will be on the other matter, which is the comment immediately after the meeting about you ought to take your you ought to keep your under control. And in regards to that, you need to consider whether on the balance of probabilities that you're satisfied that the subject member breached the Catfield Code of Conduct. So the issue, looking at the issues here, it's essentially agreed that the comment was made. So the outstanding issues for you to consider in regard to that is the question of capacity and also the issue as it's been raised as to the right to freedom of speech. So the question of capacity is, in order to breach the code of conduct, you need to be acting in your capacity as a councillor. You've heard, and by way of very brief summary, you've heard the investigating officer, the independent person, and the subject member on this matter. You've heard that it happened immediately after a meeting. It was outside the venue. The argument of the investigating officer and the independent person is that it related to council business, and it relates to keeping that meeting in order earlier. And Councillor Bacon says that he wasn't acting in capacity, he'd left the building, he was approached, so he didn't invite a further continuation of the meeting, and that it was a limited brief exchange between two men after the meeting. He also raises that he has a right to freedom of speech, and he says that he adds that he was acting in his personal capacity and could make that comment in that way. So you'll look at, in regard to freedom of speech, also raised with you, was it political expression or was this an abusive comment? So in summary, you'll consider all of the written and oral evidence that you've heard today, and the representations you've heard today, take that into account into your considerations as to whether the subject member, on the balance of probabilities, breached the Catfield Code of Conduct. Thank you.
Okay, thank you very much for that, Officer Jordan. At this point, the committee members will retire and review what's gone on and what will come back with our decision. Thank you.
You, do you want something?
I'm fine, thank you.
That's you. Pardon? Not long. You sent a copy of the procedure, weren't you? I don't know how long they'll be. Yeah, you've got that, haven't you? I wouldn't like to say these things. It's you just never know. Oh, my apologies. No, I've got mine on as well. Apologies.
Okay, thank you very much for bearing with us. As you sure you understand, we had to be thorough. Okay, basically, in relation to our decision regarding these issues, we've considered all of the information before us today, and a summary of our findings is as follows. With regard to the allegation that the subject member generally treated others with disrespect at a meeting, we note that there was no breach found by the investigating officer, who considered and provided us with the minutes of the relevant parish council meetings. Having heard from everyone here today and with consideration to the papers and the investigator, we find that there's no breach in this matter. With regards to the other matter, however, we do find a breach. This relates to a comment made, "You ought to keep your mother under control." This was made to a parishioner just after the meeting. It is not disputed that the comment was made, and we've considered the issues of capacity and freedom of speech. In capacity, we find that on the balance of probabilities, the subject member was acting as a councillor. Whilst the subject member suggests that he was not acting in his capacity, as he was leaving following the closure of the meeting. However, the proximity of that meeting to the comment is relevant. The time, the comment was made immediately after the meeting. The place, the comment was made in the vicinity of where the meeting was held. And the subject matter, the comment related to what happened in earlier on in that meeting. Whilst the subject member has the right to the freedom of speech, what he said is not protected, but is a personal and abusive comment. This is simply not acceptable, and given our views regarding capacity, we consider that this comment breached the Catfield Code of Conduct, in that the subject member did not behave in a way or manner that is a reasonable person would respect and regard as respectful as a councillor. Thank you. As you've just heard there, we've found a breach, and it's up for the committee now to consider, if any, what sanctions should be imposed. I'll invite the monitoring officer, Cara here now, to outline what sanctions are available.
Thank you. Any sanction that the committee imposes must be reasonable and proportionate to the breach identified, and should be relevant to the subject member's behaviour. Sanctions which may be considered, and in particular because this involves a parish council rather than a district council, it will be by way of recommendation to the particular parish council, and may involve consideration of a report of the committee's findings made to the parish council, issue of a formal censure outlining the committee's displeasure, that the subject member makes an apology. If the subject member sits on any committees, recommendation of removal from committees, that the subject member undertakes specified training, that could be in code of conduct, equality training, etc., any matter that the committee considers appropriate, or that the parish council withdraws facilities provided to the subject member for a limited time, or excludes him from the parish council's offices other than when attending formal meetings. But in regard to actually all of those recommendations, but in particular to the last two, in regard to withdrawing facilities or exclusion from council premises, any sanction must not unduly restrict the member's ability to perform his duties as an elected member.
Thank you. At this stage, I'd like to invite representation from the investigating officer, the independent person, and the subject matter, subject member.
So in addressing you, I would remind you that the subject member has been given various opportunities to proffer an unfettered apology to the parishioners concerned and has declined to do so. Had this been taken up, it would have avoided the need for this matter to proceed through this very timely and costly process. Despite this, I am still of the view that the breach identified falls within the scope of an apology from the subject member to the parishioner and the parishioner's mother. And wonder whether now, with a finding from this committee, the subject member may be more inclined to accept his actions were not appropriate. With regards to an apology or the recommendation of an apology, I do appreciate that this might appear a low-level sanction. However, in support of my recommendation, I would refer you to a particular case that goes back to 2013, and this was a case that was adjudicated in the administrative court. It's Benjamin Denny versus London Borough of Ealing. And in this particular case, a councillor posted on a blog comments about some residents of Southall stating, and I'm quoting now what he put, "It is a largely Indian community who say they deplore this behaviour, but yet it is the very same community that harbours and exploits their own people in squalid third world living conditions. The exploding population of illegal immigrants is a constant on the public purse. Illegal immigrants don't pay tax. The legitimate immigrants exploiting them in the squalid bed sheets, sheds, don't pay tax on their rental income. If these are the sorts of people who exploit the desperate, what other scams are they perpetrating, I ask? Criminality is endemic in Southall." In this particular case, the court upheld the original committee decision and required the councillor to issue a public apology. And I would ask you to note the sanction in this matter for what was a very public and racist attack on the Indian community in Southall. So this was a public statement, and therefore a public apology was fitting. In this matter before you, the comment in question was made outside the hearing of any other person, and accordingly, an apology to the individual concerned would be, or the two individuals concerned would be commensurate. You may also wish to consider that the subject member attends some general standards type training or some equality and diversity training.
Thank you. The independent person, do you have an input?
I've only just one thing to say, that my concern now is the subject member's own comments. He didn't think it was abusive or offensive. That is a problem moving forward. And that is why I commend the training, because he needs to understand what is acceptable language.
Okay, thank you. Subject member, do you have any comment? In that case, as a committee, we'll yet again retire to consider what options we have, and we'll return. Thank you. Okay, thank you very much for being very patient. We tried to be as speedy as we could. Moving on, as we said before, we considered there had been a breach and retired to consider what sanctions. We've considered what sanctions should be imposed. In doing so, we've considered what we've heard and read today. Looking at matters that mitigate and aggravate your conduct, mitigating factors, the independent person has outlined what we consider are mitigating factors. It was a long meeting where there was some extreme aggravation. You were approached but did not set out to make the comment. You said you did not want to talk, but then unfortunately did and made the comment. Aggravating factors. You failed to take the opportunity or opportunities that were given to you to make an apology, to resolve this matter without having to go to this. We note your long public service in the parish council and charitable endeavours, and given your experience, we are actually quite surprised at your comment that you made. Though you do note and we know that you said you found the meeting extremely stressful. With regards to those mitigating and aggravating factors, etc., we recommend the following sanctions to the Catfield Parish Council. 1, an apology that is a clear apology in writing is made within 28 days to Mrs. Snelling and Mr. Snelling and acknowledges that the comment made was disrespectful. 2, training. That code of conduct training and equality and diversity training is undertaken by the subject member within 6 months from the date of this meeting, and recommend that the Catfield Parish Council arrange such training within this period. That's just a summary. Obviously, a full written decision will be available within 5 working days of this hearing. Thank you all very much for your patience and input and the way you've behaved. And I will now close the meeting. Thank you.